Many foreign investors assume that once a shareholders agreement is signed, their rights are fully protected. The document is detailed, negotiated, and often reviewed carefully. But in Vietnam, a signed agreement does not automatically mean it is enforceable in practice. The real question is not whether you have a shareholders agreement in Vietnam, but whether that agreement can actually be enforced when it matters. Enforceability under Vietnam law refers to whether a legal document can be recognized and upheld by authorities, courts, or third parties. A shareholders agreement in Vietnam is a private contract between investors. While it is legally binding between the parties, its enforceability depends on how it aligns with Vietnam company law and other registered documents. One of the key challenges with a shareholders agreement in Vietnam is that it is not a public document. It is not filed with authorities and is not part of the official company records. This creates a limitation. While the agreement may define detailed rights, those rights may not be recognized in administrative procedures or when dealing with third parties. In practice, the company charter in Vietnam is the primary document relied upon by authorities. It defines the official governance structure of the company. If the shareholders agreement contains provisions that are not reflected in the charter, those provisions may be difficult to enforce. This is one of the most common issues foreign investors face in Vietnam. Conflicts between the shareholders agreement and the company charter can create serious legal uncertainty. For example, an agreement may grant certain approval rights to an investor, but if those rights are not included in the charter, they may not be recognized in practice. This gap between private agreement and public document is a key enforcement risk. Certain clauses in a shareholders agreement in Vietnam are particularly sensitive from an enforcement perspective. These include voting arrangements, transfer restrictions, and management control provisions. If these clauses are not properly structured or aligned with Vietnamese law, they may be challenged or become ineffective when disputes arise. There have been cases where foreign investors relied on their shareholders' agreements to protect their rights, only to find that those rights could not be enforced. In some situations, investors were unable to block decisions or exercise control because the relevant provisions were not reflected in the company charter. These risks are not theoretical. They are common in practice. To ensure that a shareholders' agreement in Vietnam is enforceable, it must be carefully structured. Key provisions should be aligned with the company charter and comply with Vietnam company law. The agreement should also be drafted with practical enforcement in mind, not just theoretical protection. This requires a clear understanding of how legal documents operate in Vietnam. Many enforcement issues cannot be fixed after the agreement is signed. They originate from the drafting stage. A poorly structured agreement may appear strong but fail when tested in real situations. Foreign investors in Vietnam, this highlights the importance of professional legal drafting that focuses on enforceability, not just completeness. At LTS Law, we provide legal services for foreign investors in Vietnam by drafting and reviewing shareholders' agreements with a focus on enforceability. We ensure that your agreement aligns with the company charter and complies with Vietnam law, so your rights are protected not only on paper but in practice. Before relying on any shareholders agreement in Vietnam, visit lts.com.vn and consult with our legal team to ensure your investment is fully protected.